And let's bring in our panel, NBC Justice and Intelligence correspondent Ken Dilanian, former federal prosecutor Paul Butler. So, Ken, starting with you, let's talk about the D.C. case. Describe the protective order. What is normal in this circuit? I heard Chuck Rosenberg saying this morning that in all of his cases, he always had a protective order, and it was usually agreed to at arraignment by the defense.
That's right. And Paul can speak to this as well. This is a standard procedure in a criminal trial because there's a lot of sensitive information that the prosecution must turn over to the defense, including transcripts of witness interviews, phone records, text messages, things that were taken under subpoena or search warrant. And the judge does not want the defense making that public. And normally the defense doesn't want to make it public either. But in this case, Donald Trump and his lawyers are asking essentially for permission to make some of that information public. And Jack Smith responded last night in a filing saying, look, they just want to try their case in the media. And not only shouldn't you allow a judge, but local D.C. criminal rules don't allow them to do that. And so you should impose our protective order. But interestingly, the judge didn't do that. The judge asked both sides to come in for a hearing.
And perhaps the judge is trying to protect herself and the record to make sure that both sides have an opportunity to discuss this, to brief on it, and to argue it in court for any potential appeal. There'll be a lot of appeals in this case for sure. And I just referred to Chuck Rosenberg, who, Paul, like you, has tried a lot of cases here. And this is what he had to say this morning on Morning Joe.
I don't think I ever prosecuted a case where I didn't have a discovery order and a protective order. And by the way, I never had an issue with it. And the folks on the other side abided it, and it helped to streamline the process. That's a key thing to understand here. Mr. Trump's attorneys don't want to help streamline the process.
So they are getting more time here because it's taken a couple of days, although she has not postponed the hearing date, which was August 28th. What's your take on this, Paul, as a constitutional lawyer, a law professor, and a former prosecutor?
Yeah, so a criminal defendant has the right to see evidence against him, but the public doesn't have the right to see that evidence. So it's very common in these cases for a judge to restrict how the defendant can use the evidence. We're going to see a lot more of these dust-ups. What's really revealing is the dispatch with which Judge Chutkan has handled this case. So Jack Smith files the motion on Friday. On Saturday morning, Judge Chutkan orders Trump's team to respond. They got to respond by Monday, she says. They asked, Judge, can we have more time? She said, when I said Monday, I meant Monday. And now she's going to have the hearing this week. So that suggests a judge who wants to get this case tried.
And in the D.C. circuit, there are rules for defense lawyers, for trial lawyers, I guess, on both sides. And does going on television and making as public a case as they are, is that against any of the rules, or is this a special case? The man is running for president of the United States. And there are all kinds of reasons for not interfering with his freedom of speech.
Yeah, so it's not against the rules, but it's interesting in that Jack Smith and the Trump's defense team, they're not that far apart on this issue. So Trump's defense team concedes that there needs to be some restrictions. They're saying that what Jack Smith is asking for is too broad. So again, part of it is this kind of performance by Trump's defense team that's really more for cable TV and for Trump's political base than it is for Judge Chutkan.
But it's also to create the atmosphere that he is being censored and that this First Amendment issue, they say, is a key part of their defense, even though many legal experts can say that that really shouldn't be part of the case, that is not for the court of law.
That's right, that speech in furtherance of a criminal conspiracy is not protected by the First Amendment. But I think this is setting up another fight down the road, which is, at what point do all Donald Trump's attacks on the prosecutors, the judge, witnesses in this case, cross some kind of line for a criminal defendant? Because the D.C. local rules do impose certain restrictions on what lawyers from both sides can say about the evidence. They're really not supposed to go on TV and describe the evidence in detail. And but as you said, he's running for president, so he's got a First Amendment right to speak. At what point, if at all, does the judge step in and say, hey, there's a line and you can't cross it? And then, of course, if she does that, that will be appealed and all the way.
Another judge here did say that Roger Stone, a previous defendant, of course, so close to Donald Trump, had crossed it when he put, a target like a bullseye and the judge's face superimposed on it. and then violated a restraining order, a gag order. So he went too far. Plenty of precedent for that, but not in this case. This would be really inflammatory on the campaign trail. We just saw how people in New Hampshire selected people around a Trump rally already reacting to it. Let me ask you about Aileen Cannon, because there's some controversy over what she has done in the classified documents case. The backstory here, the prosecution filed a motion regarding a conflict of interest among lawyers just to get it on the record, because one lawyer was representing some 7 defendants, Walt Nauta and others, and they had to have an open hearing. I think that's called a Garcia procedure, if my TV law school is coming into play here. But as a part of that, they filed in that motion that they do have a grand jury sitting here in D.C. also on related obstruction charges, which were actually raised in the superseding indictment. That set off her wanting them to respond not just to the conflict of interest issue, which they had appealed on or wanted to bring up, but that they explain why they have another grand jury in another jurisdiction. Is that a big deal?
I don't think so. I think that she's the judge supervising the grand jury. She has a right to know how they're using these grand juries because, Paul would know better, they're not supposed to use a grand jury to investigate a case that's already been indicted. But if they're using it to investigate further allegations that could lead to further criminal charges, that's okay. And the judge wants to know the answers to those questions, I think.
But what if the people that they're talking about in this superseding indictment are also going to be witnesses in this case? Is that a no-no?
So again, grand juries have jurisdiction to investigate where the crime went down. So the judge is asking, well, how can this grand jury investigate in both D.C. and Florida? Well, the indictment alleges obstruction of justice in both of those places. And Ken is absolutely right. Jack Smith has indicated that the Mar-a-Lago investigation is ongoing, which means that the grand jury has the power to continue to investigate, even as we've seen, to bring a superseding indictment. It's not supposed to do catch up with the charges that have already been filed, but so far we've seen no evidence that that's what Jack Smith is doing.
Well, importantly, what they came out with in the superseding indictment was evidence of an alleged attempt to get rid of the video evidence from the surveillance cameras, which is a whole new issue that was not
historic
raised.
Charges that we don't even talk about because we're on to the next thing already. It's amazing.
And the political fallout already, Ken, I know you're not doing politics here, but what we've seen is that this has resonance and the prosecution has to worry about it. I know you're going to have voir dire and a jury selection, and then that's a very important part of this case in Florida as well as in D.C.
It has resonance. And, Jack Goldsmith, a former, Bush administration lawyer who's well-respected in a lot of circles, has an article in the New York Times today arguing that this whole prosecution is a bad idea. It's bad for the country, and that Republicans just aren't convinced of the legitimacy of it. And I think that's the latter point is certainly bears up by the evidence.
The country is more divided than I think I've seen it at any time over this issue, and it's going to dominate the campaign. Paul Butler, thanks for helping us sort through it. Ken, you are invaluable, of course, my colleague here.